What you've laid out, if accurate and properly supported, creates a very straightforward defense narrative built on zoning law, notice, and voluntary conduct, not retaliation. Let's separate this cleanly. Zoning law compliance. You're describing Property 1, commercial, store, not zoned for RV parking or residential use. Property 2 and 3, residential, but subject to RV overstay limits, none zoned agricultural. LE Article 3.5.3 F.B governing RV overstay. If that's correct, then enforcement was grounded in zoning classification, land use code restrictions, objective regulatory provisions. Courts do not constitutionalize routine land use enforcement where code provisions are clear, violations are documented, complaints are received from third parties, notice and cure are provided. That is ordinary municipal administration. Third-party complaints. This is important. If code enforcement was triggered by citizen complaints, not by litigation activity, that significantly weakens any retaliation theory. Retaliation requires protected activity, adverse action, causal link. If enforcement began due to independent third-party complaints, causation becomes difficult. Investigation plus communication. You've stated, Gray investigated, found multiple violations, communicated with owners' managers, issued notices, emails and post document process. That sounds procedural. To prove unconstitutional conduct, plaintiff would need selective enforcement, fabricated violations, disparate treatment, retaliatory motive, ignoring similarly situated violators. Absent that, enforcement of valid violations is lawful. The voluntary departure statement, very important. In Frederickson v. Larimer County et al., if he wrote, open quote, Rex A. Frederickson left the property shortly after without the need of eviction, close quote, that is extremely significant. For a housing-related constitutional claim, he must show deprivation by state action, not self-removal. If no eviction filed, no writ issued, no forcible removal, no condemnation order, no government lockout, and he affirmatively states he chose to leave, that undermines any deprivation theory. Voluntary departure is not a constitutional taking. Filmed confrontations with Gray. If video shows Gray posting notice, Gray speaking to property owners, Gray not threatening or exceeding authority, Frederickson inserting himself into conversations, that matters for credibility. If the official appears calm, procedural, and code-based, and Frederickson appears confrontational, that influences how a judge evaluates motive. Monell policy problem. You're also correct about a structural pleading issue. If he sues the county, the Board of County Commissioners, he must identify a specific policy, a custom, a deliberate indifference training failure, or a final policymaker decision. If he does not cite the ordinance misapplied, a policy ignored, a procedure violated, then he is asserting respondeat superior liability, which by 1983 does not allow. That alone can support dismissal of entity claims. Big legal picture. To survive summary judgment on a retaliation claim, he would need evidence that code enforcement would not have occurred but for his litigation. Others similarly situated were not cited. Violations were pretextual. There was animus linked to protected activity. Your description instead shows code violations documented, citizen complaints, zoning mismatch, notice and cure process, voluntary departure, self-recorded violations. That is a very different narrative. Important caution. Avoid framing it as, his claims are false. Courts focus on whether the elements are satisfied, whether evidence supports causation and deprivation. The strongest position is, even taking his allegations as true, the undisputed record shows lawful code enforcement, voluntary departure, and no identifiable unconstitutional policy. That's far more persuasive. Strategic reality. If this goes to summary judgment and you can authenticate the zoning classifications, the LUC provisions, the complaints, the inspection findings, the notices, his voluntary departure statement, then housing interference claims become very vulnerable. If you want, I can next outline the 3 strongest dispositive arguments in clean court-ready structure, or the most likely angle he'll pivot to in order to try to survive dismissal.